and we rely on our affidavit in opposition and statement of case filed on the 17th of February. My lords, it is our respectful view that this application does not appropriately invoke the special duty jurisdiction of the court under Article 133, as well as Rule 54 of CI 16. Lords, we are submitting to this honorable court that this application is a classic case of an aggrieved party who has become emotional by the decision of the court, seeks to re-argue his case through the back door of apparently review application, which it is not. And for these reasons, my lords, the application ought to be dismissed. But we would like to make a few other points. My lords, counsel has referred to Section 26 of the Evidence Act. And whenever he does so, he fails to recognize that that section is subject to any other law or rules of equity. And my lords, in our view, under 38, the 3E is any other law. So this is not a situation where you can argue that you are using a subsidiary legislation to trump a substantive legislation. Because if one goes to Article 11 of the Constitution, which defines the laws of Ghana, it includes subsidiary legislation. Now, my lords, again, the petitioner cannot seek refuge, even if it is true, in the fact that the application was argued not on grounds 38. Why? Because before the court, there was extensive argument on that order. 38. Sorry. Order 38. There was extensive argument on both sides, including questions by the bench. So it does not lie in his mouth now, after the fact, to suggest he couldn't be suggesting that he was taken by surprise. He had every opportunity to advance his arguments. We also advanced our arguments, showing how secular his arguments were, how completely misconstrued his attempt at interpreting the various sub-rules under Order 38, Rule 3, E was. So, my lords, it is our submission that this court is entitled to ignore all the arguments that have been advanced today in respect of the correctness or otherwise of the use of Order 38, Rule 3E. Then again, my lords, we do not see the relevance whatsoever of a reference here to Article 19.3 of the Constitution, which is a criminal matter, deals with criminal matters. and also Article 296. My lords,
actually, I did not refer to Article 19.3. I referred to Article 19.13.
Very well. My lords, I'm sorry. My lords, my other point here is that now a major foundation of this application is the interest of justice. My lords, we all know that when courts rule based on the interest of justice, it's not at large. It is in reference to the specific circumstances of each case. So, my lords, it cannot be that the interest of justice is a ratio. I mean, it cannot be.
To the Article 19, Clause 13.
No, I'm move from that.
Yeah, okay.
Yes.
Yeah.
Yes.
Carry on.
Yes. My lords, I'm saying that one cannot use the interest of justice as declared by a court in a particular case as a general wand, magic wand. You know, any case, you say that, oh, in that case, by the interest of justice, which of the ratio should apply there. It cannot be so. Every articulation of a decision based on the interest of justice is grounded on the specific facts as assessed by that particular court. And this court, or the ordinary bench, had assessed the facts of this case and did not find that there was any compelling interest of justice for it to grant the application based on. And my lords, this is so, in my view, respectfully, because this whole case is based on a fiction. It's based on a fiction. No, the whole case. Now, which this is a subset. Yes, the petition. It's whole based on a fiction.
That's at the tail end of your...
No, that's relevant.
No, please, we are dealing with this application for review.
But the application
so he has argued at length. We extended time for him, so take your time. Don't go to the substantive matter. Yes, we have given a ruling and they are seeking a review.
Yes.
Yes.
So, my lords, I believe and submit that this application is completely unmeritorious, and does not satisfy the very strict conditions for review laid out in Article 133 of the Constitution and Rule 54 of this court's rules. We accordingly pray that, yes, it's more or less, it's a special jurisdiction under the Constitution, yes. So, and if it isn't, more so, that course should be awarded.
Mr. Kotuapa, I'm interested in why you permitted Mr. Kweku Esrifi to swear, to depose to the affidavit in opposition on behalf of the second respondent when he is not on record as the attorney for the second respondent. What we have on record is that Mr. Kweku Esrifi is one of the counsel that's announced in this case. Is there any justification why?
Yes, my lords. The attorney has powers to testify.
There are factual matters that has been deposed to. We have been told that one Peter McMenu is the attorney for the second respondent.
Relax.
We are from this practice where lawyers who are engaged by parties take it upon themselves to depose to affidavit when the parties are there. Can you justify it?
My lords, as I've indicated, lawyers take instructions from their client. Our client is the second respondent. Mr. McMenu was given a power of attorney to go into the witness box if necessary to testify. So that is the distinction.
And he has given power of attorney to...
No. My lord, you seem not to understand me. The attorney, power of attorney, was simply for him to go into the witness box in relation to his witness statement.
So when an affidavit will have to be sworn to, who is it lawyers who swear affidavits on behalf of clients?
Well, my lord, in circumstances like this, I believe that it is in order and permissible for lawyers to swear to affidavits.
Very well.
Yes.
Lords, respectfully, if with your leave, I may just make two quick points, because reference was made by my learned friend to the first words of Section 26, except as otherwise provided by law. And my learned friend made that reference in order to suggest that perhaps there is some other law that enables 36 to be put out of court. Well, my lords, our ground is that your lordship's decision respectfully was per incuriam of Section 26. It's not as if your lordships adverted to Section 26 and then said that because of some other law we are not going to apply. That's not what happened. Your lordship didn't advert to it. Now, and it's quite clear in their opposition. It's quite clear that that's what happened, because they then tried to use your lordship's ruling on the 16th of February. They tried to use that.
My lords, we have not tried to use that. So my counsel should not refer in responding to my submissions that they have used it. We have not made any such reference in our affidavit.
There's such a unity of purpose.
There isn't. We are different parties.
And my lord, my only other point by way of response is that counsel for the first respondent asks, what reliance did we place on the depositions that were made? Evidently, we relied on that to close our case, as we did. Because, my lord,
is it a point of law?
I'm sorry.
Is it a point of law?
I'm sorry.
Is it a point of law?
Is it a point of law?
Yeah, what you want to respond?
Well, my lords, the issue was really whether we have relied on it. That's a point of law, whether they have been relying, because they're saying that
it's not a fact. It's not.
I think, my lords, so my lords, on what evidence are your lordship? No, on what evidence are your lordship?
Order.
Respectfully, then the question is, on what evidence are your lordships going to determine that matter of fact? No, it's not. Respectfully, this, I think, is an appropriate situation where it's really a mixed question. It's a mixed law, in fact, because he is saying that legally, the reliance on the deposition is part of what kicks in Section 26. And my point is that, yes, in reliance on that deposition, we close our case. I mean, we need that evidently clear in this court, because
so you've made this point, but their view is that you did not rely on it because you pursued those applications. Your view is that you relied on it, and it's on that basis that you closed the case. So we have heard both of you.
It is not just my view, because the question whether we relied on it, it really lies within our court, much more than their speculation. Because nobody can speculate in terms of the conduct of our case. The conduct of our case, as we had it, relied on, because when you come to court, you rely on what comes to you from the other side as well. So, my lords, we clearly relied on that conduct. And our main submission on that Section 26 is that your lordship did not advert to that, much less try to
realize that you did not, in your submission on that day, you never referred to Section 26. On the submission, during your submission.
My lord, on that day, your lordship asked me, is it an estoppel argument?
No,
and I said, yes.
So that was the answer. You did not refer to as Section 26. Section 26 have come into play in these proceedings during the last arguments. That was when you relied on, because I've looked at the proceedings of the 9th February.
Yes, my lord, I did not refer to Section 26 on that occasion because, my lords, the question about estoppel, your lordship asked me, and I said, yes, it was estoppel. I did not refer to Section 26, but that's a matter of...
The question about estoppel was asked during the last...
My lord, your lordship asked me the question about estoppel during the transfer.
That is what caused you to write to us, that you needed to give further submissions.
No, my lord, respectfully, my lords, no, that is not the case. The transcripts are very clear, respectfully.
I have a question.
Yes.
I have a question. My question is, these affidavits, were they not sworn to before the trial, before the hearing? They were sworn to during the interlocutory application.
My lords, affidavits sworn to during...
No, I'm just asking a question. Were they not sworn to before you put your witnesses in for hearing?
Yes, they were.
Thank you.
And my lords, that has no significance for the reliance. It has no significance for the reliance that we placed on it in the conduct of the case. Because your lordship will...
Satisfied with the answer?
Well, you can't be satisfied with your answer.
Order.
Yes.
Order, please.
My lord, you can't be satisfied when I have not completed my answer.
Order in court, please.
I've not completed my answer, and your lordship says I'm satisfied with your answer. You're cutting me short in giving an answer that will address what underlies your question, because what underlies your... If my lady can allow me...
Just a minute. Respectfully, Mr. Chikata, these are matters of fact. The date on which the affidavits were filed, the date on which the trial was conducted, these are matters of fact. So I could even come to that, I could do that evaluation without asking you a question. I chose to ask you the question so that you could avert your mind and confirm. That is all.
Yes, but
so answering my question.
So may I complete my
answer? Very well, Mr.
Because, my lord, when affidavits are sworn to in interlocutory proceedings, in the course of a trial, it is open, for instance, to put the matters that were deposed to in an affidavit in an interrogatory proceeding to the witness when he enters the witness box, and to put before them, did you say this on oath in an affidavit before this court? This is a matter that is quite basic in the practice that I'm familiar with, that when you have an affidavit sworn on oath in interlocutory proceedings, and a witness comes into the witness box to testify, that affidavit can always be put to them in terms of the veracity of the things that they say. So you can't say that just because this was done in the course of interlocutory proceedings that were before the trial itself, they have no bearing on the conduct of our case. Because my lady will recall that this whole matter of crossing the bridge when we get there was in terms of whether address those matters. And indeed, that is precisely what we did. Because your lawsuits ruled against us, so we had to wait for the cross-examination to take place. And we waited on the basis of sworn affidavits by the chairperson of the first respondent.
The court advised to consider his ruling.
All right. Profit.